My name is Monica Milton, Counsel for Public Defense and Special Projects here at NACDL, welcoming you to another Engage and Exchange this week about the criminalization of voting. Just a few housekeeping before I pass it over to our Executive Director, Lisa Wayne. If you have questions for the panelists today, please drop it in the Q&A function located at the bottom of your screen. If you want to talk amongst yourselves, you are free to use the chat function, and the moderators will get to the questions as time permits. And so this program is being recorded, and you'll receive this along with any other materials that happen to come up during today's session in a post-program email. So without further ado, I'm going to hand it over to Lisa Wayne.
Thank you, Monica. Good afternoon, good morning, wherever you might be. And I really appreciate all of you for attending what is a very important webinar this afternoon here in DC. NACDL is about promoting equity, justice, and fairness. A lot of people think to themselves, well, why as a criminal defense lawyer do we care about voting rights? And it's the overcriminalization of voting rights that have taken place in this country as we see it today. It's important because when that includes making it a crime to exercise your right to vote. That it can include voter intimidation, fraud, and just bullying people who have paid their dues, who are out of prison, who have the right to vote, and making them afraid to exercise that right. So I'm so appreciative to this committee, the Voting Rights Committee over Criminalization of Voting, for putting together what is a critical and timely program on something that we all should care about. They have brought in the experts around the country, and they are doing a lot of work on this committee and encouraging anyone who might be interested in this to give them a call and reach out and join this very important committee of NACDL. I also want to remind everyone that is on this webinar that this is a really, I keep saying critical, but that's what it's all about these days. It's a critical moment in our history to join this organization. Defenders are being attacked on in the trenches, on the sidelines, on every front that you can imagine, and this organization stands for us. We are doing this webinar for free. We're doing it for free because we can put out messaging that hopefully will impact a number of folks in this country, but we would love you to join us so that that message can be strong and to unite it together. So again, I want to thank Seth Chazin, Ray de la Cabada, the chairs of this committee, and all the hard work that you're doing. And thank you all again for being here.
Thank you for your remarks, Lisa. Good afternoon, everyone. My name is Tamara Lewis, and I'm the Director of State Advocacy at NACDL. And I have the pleasure of introducing Seth Chazin and Ray de la Cabada. They are the co-chairs of the Criminalization of Voting Rights Committee, and they are the moderators for today's conversation. Seth and Ray, the floor is yours.
Good afternoon, everybody. Thank you so much for being here. And I'm going to be brief because I want you to hear our speakers. People often get upset about what's going on in the country and how it affects us criminal defense lawyers. And what I tell people all the time is, you can either, complain about it from the cheap seats or you can get involved. And ACDL, for the last 15 years or so, have given me an outlet to do something that I believe in, to not just have it be about myself, but be about the institutions that we're protecting. This Criminalization of Voting Rights Committee is an extension of a belief Seth and I and NACDL as a whole were insulted by efforts that were being taken to criminalize people's rights to vote, particularly returning citizens. We formulated this committee, and it's been a work in progress in training criminal defense lawyers and talking about the most temporal issues and relevant issues in defending these cases. With that, Seth is going to introduce the speakers, but we have someone that's actually tried a case, did an excellent job, Andrew Darling, and we have Patrick and Jake who are going to talk about different ways of attacking these laws that are trying to suppress individuals' right to vote. So now more than ever, when people need to be heard, I think this committee takes a heightened importance. And Seth and I's function is to monitor this with Tamara's amazing assistance and seeking out different states that are having this problem and creating resources, training. We've done a variety of different things, but consider us a resource in helping you defend this case, these types of cases across the country. So with that, I'm going to turn it over to Seth. Thanks again for being here. I'm very excited to hear what these people are going to say, and I think you're going to find it fascinating. Thank you.
Thanks much, Ray. And thank you, Monica, Tamara, and Lisa for your leadership. And welcome, everybody. Needless to say, on the tail of election day yesterday, this is, I think, going to be a timely discussion. So across multiple states, individuals have faced criminal charges for honest mistakes or for performing their duties as election administrators. As investigations and prosecutions related to voting and election administration rise, defense attorneys and advocates are confronting new legal and ethical challenges. So this discussion today will highlight recent court victories, share defense strategies to protect our clients, and analyze emerging trends. I want to introduce our esteemed speakers. First is Andrew Darling. He's a criminal defense attorney based in Orlando, Florida, with extensive experience handling complex cases. As Ray mentioned, he tried one of the election fraud cases, and so he's going to have some real practical experience to pass on to us. He received his law degree from the University of Miami School of Law and is known for a strategic and client-centered approach in representing his clients. Andrew will discuss today a recent voter fraud case he took in Alachua County, Florida, and the strategy he used to represent his client. Next is going to be Patrick Berry, Counsel, Voting Rights and Elections Program for the Brennan Center for Justice. Patrick serves as counsel in the Voting Rights and Elections Program at the Brennan Center. He advises lawmakers on policy, litigates voting rights cases, and provides commentary on voting-related issues to the media. Patrick received his BA from the University of Central Florida and his JD from the University of Pennsylvania Carey School of Law. Patrick is going to discuss the rise of investigations and prosecutions targeting voters and election workers, which is a big problem right now, particularly under this administration. Lastly, but not least, is Jake Sussman, Chief Counsel of the Justice System Reform Southern Coalitions for Social Justice. Jake is Chief Counsel of the Justice System Reform Team at the Southern Coalition. He's an appellate and civil rights litigator with experience handling indigent defense cases, complex criminal cases, and death penalty matters. Jake received his law degree from the NYU School of Law, where he was a public interest scholar. Jake is going to discuss a recent Fourth Circuit win, reinforcing legal protections for those with criminal records who have attempted to vote. So with that, Andrew, take it away.
Hey, good afternoon or good morning, wherever you are. Thank you all for having me. I really appreciate it. The case that I'm going to talk about that I was fortunate enough to try is John Rivers in Alachua County, which is Gainesville for those of you outside of the state of Florida. Gainesville is college town, but also it's Alachua County is mostly a rural place. Gainesville is not a big city, and as the same way, Alachua County is not really a big county. But Ray reached out to me, along with the organizations down here in Florida. Let me start here. In 2018, the voters of Florida passed Amendment 4, which was to restore the rights of returning citizens, former felons, people who previously had convictions, to restore their rights automatically. Then the Florida legislature in 2019, it was either the middle of 2019 or right before 2020, they were able to pass an additional requirement that was not in the constitutional amendment, which meant fines and fees were included in what individuals, returning citizens, had to make sure was completely paid off before they could actually vote. The issue with that was there was no central database. There still, in 2025, is no central database for somebody to know this. So you have to go to every county individually, to every clerk of court, to figure out, do you owe any money to anybody anywhere? So this is the environment that we were working with at that time. So what I'll share with you, and I'm reading from the actual information, the charging document for Mr. Rivers. He was charged with 2 counts, false swearing or submission of false voter registration information. That is essentially for him filling out the voter registration card, the voter registration application. And then the second count was unqualified electors willfully voting. So the actual act of voting itself was the other crime. So both of these third-degree felonies, they are from the 2020 election. He was charged in March, I believe it was, March of 2022. And we went to trial, I believe it was end of 2022 or beginning of 2023. It feels like a lifetime ago now. But what the issue ended up becoming, and here's some of the details that are probably going to upset some of you. Mr. Rivers was in custody, pretrial detention. He had finished all of his stuff that he'd previously been convicted of. He had a new arrest that he was being held for in the Alachua County Jail. Prior to the election, the Alachua County Supervisor of Elections office went into the Alachua County Jail because the reality is some people that are still being held pre-trial are not convicted of anything and they are eligible to vote. The problem was the person that they sent in was not doing a great job of explaining what the requirements would be if you had previously been convicted of a felony. So they essentially said if you weren't a murderer, if you didn't have a sex offense, you were going to be eligible just based on you completing your time on these prior offenses. So we get through the trial, and I'm going to kind of give up sort of the result here early, just to kind of let you know. But the jury found him not guilty on the registering to vote, but they found him guilty on the actual act of voting, which to me, and I still do occasionally beat myself up about this, I feel like I stayed away from count 2 a lot in closing argument because it sounded ridiculous to me that somebody could be not guilty of registering to vote, but then guilty of the actual voting. It didn't make sense to me. But what ended up happening was the offense that he was being held on, when he registered to vote, he was eligible. Prior to his registration in 2019, it was the end of 2019 when he registered, and the actual vote itself, where he was out and voted, he was on probation for a new offense. So one of the things that I argued, and the part about the trial that I still beat myself up about, is I don't feel like I argued enough that withhold, he ended up getting a withhold of adjudication, which may or may not have been lawful based on statute, but whatever. He got a withhold of adjudication for that offense that he was on probation for, which in Florida is different than a lot of places. It's not technically a conviction. So while you are on probation, it is almost treated like a conviction for purposes of rights restoration. But while you're on probation, you're not actually convicted of a new offense. So you are on supervision, but what ended up happening, and this is where the jury sort of split the baby, if you will, they made the decision that because he had pled to that new offense, that he knew at that point he was no longer eligible to vote. So I vehemently disagree with that. I mean, there are folks that have never been in trouble that you could ask these questions to. There are folks that have been in trouble their entire lives. There's almost no consistent way to answer these questions unless you do this work for a living. There's just not a good way. There's not a good cheat sheet. There's not a good checklist at all for people who are in this situation. The one big win that I was able to get in this case and it was piggybacking on a case that I believe happened right before mine in Ray, you may remember, I believe it was Miami. There was one other case. I can't remember if it was Miami or Tampa, but
It
there
was
was,
Tampa.
yeah, there was Tampa. So,
Hillsborough.
yep. So one of the attorney down there was able to get in the jury instructions a good faith defense. So that was something that we fought really hard for. The Tampa case was the first case. I believe my case was the second case that actually went to trial. And what we were able to do, and I'm just going to read from it. I literally printed it out here before this process. But the good faith defense, this is what we were able to add into the jury instructions. So obviously, here's what the actual jury instructions were for the state to prove false swearing or affirming. So it's to prove the crime of false swearing or affirming, the state must prove the following two elements beyond a reasonable doubt: that Mr. Rivers did willfully swear or affirm falsely to any oath or affirmation, and two, the oath or affirmation was in connection with or arising out of voting or elections. Okay. The good faith defense, and this is what I think was helpful for us, even with the supervisor of elections office arguably interfering, was the good faith defense says that it is a defense of the charge of false swearing or affirming if the defendant had an honest good faith belief that he had the right to vote. If you have a reasonable doubt about whether the defendant had an honest good faith belief, even though unreasonable or mistaken, that he had the right to vote, you should find him not guilty of false swearing or affirming. And then it's basically just the part where it says if you find the state proved beyond a reasonable doubt, you should find him guilty. So the advantage that we got on both cases was we got the good faith instruction on both counts, not both cases, both counts. So I tried the case I had with an associate that was with me at the time. We tried the case, and the judge that we were in front of is a notoriously harsh punisher. He's incredibly fair. I think he's a really good judge, but he has a reputation for punishing rather harshly. He put Mr. Rivers on probation, and it's a situation where I think he was more upset with the way these investigations took place, the way the supervisor of elections office went to the jail, and sort of the haphazard manner with which they just registered people to vote. If you guys know, in the state of Florida, a good chunk of the people that have been charged, and some of them resolved their cases, a good chunk of them came from Alachua County. And it was from this one visit with the supervisor of elections office going into the jail. So, I mean, what I would say is what I've learned through this case specifically was just that these cases, while incredibly technically complicated with who was able to vote when was this specific person's rights restored, or were they, and where the differences are, for me, the hardest part was simplifying this down to Mr. Rivers followed the supervisor of elections guidance to register to vote. He received his voter registration card in the mail. He went to his polling place when it was time for him to vote, and he cast his vote because he believed he could. That was essentially my message throughout the trial. And while we didn't get the total result that we wanted, it was a pretty good outcome. And, Mr. Rivers is, living his life. So that's all I really have about the Rivers case. I'll let Patrick and Jake go, and then I guess we'll address questions if everybody has them now or at the end, whatever works.
Thanks
Do you
much,
wanna
Andrew.
do you wanna ask him questions now, or you want to let everybody present first?
I think we were going to present first as well.
Okay.
So great. Thanks so much, Andrew. Patrick, take it away.
Thanks so much, Seth. So good afternoon, everyone, or good morning. Thank you so much for having me. Again, I'm Patrick Berry, and I'm an attorney at the Brennan Center for Justice, where I work in the Voting Rights and Elections program. So since the very start of his second term, President Trump and his administration have launched a concerted campaign to undermine confidence in our elections. And today I'm going to focus on just one piece of that broader effort, namely the targeting of election officials and pro-voter organizations. Back in March, many of you will recall that the president issued unconstitutional executive order that purported to rewrite state election rules and expand federal control over election systems. One other thing that this order did was that it directed the Attorney General to prioritize the prosecution of so-called election crimes. Now, of course, the Department of Justice can and should prosecute genuine fraud in U.S. elections, but the focus of that executive order, coupled with statements and actions taken by the president and his appointees, suggest that these prosecutions may actually end up targeting election officials and others who work to assist voters. And here's why we think this. So the president and his allies have repeatedly threatened to go after officials who administered the 2020 election. In a speech on March 14th of this year, President Trump said, and I quote, "What a difference a rigged and crooked election had on our country, and the people who did this to us should go to jail." The president's appointees have also expressed their support for these efforts. In 2023, for example, Kash Patel declared, quote, "We're going to come after the people in the media who lied about American citizens who helped Joe Biden rig presidential elections. We're going to come after you." These threats roughly track a proposal in Project 2025, which called for the DOJ to prosecute election officials over the 2020 election. Specifically, Project 2025 proposed the DOJ use Section 241, which is a federal civil rights criminal statute, to charge election officials with criminal conspiracy to injure civil rights for their alleged misapplication of state law to help voters cast ballots during the 2020 election. So far, the administration has already targeted at least one official who played a key role in safeguarding the 2020 election. In April, the president called on the Department of Justice to investigate the conduct of Chris Krebs. And Chris Krebs is the president's own appointee to lead the Cybersecurity and Infrastructure Security Agency in 2018. And the reason that the DOJ was instructed to investigate Mr. Krebs was because Krebs publicly rejected claims that the 2020 election was rigged or stolen. As many of you know, the president has also gone after law firms. Some of those law firms were targeted because of their involvement in voting-related litigation or their connections to individuals who were involved in litigation related to January 6th, litigation related to efforts to overturn the 2020 election, and then also proceedings related to interference in the 2016 election. And Project 2025 did not stop with election officials. It also urged the DOJ to ramp up prosecution of so-called voter registration fraud. And it's not hard to imagine what this type of persecution could look like or what kind of chilling effect it would produce. In states like Florida and Texas, officials have targeted organizations conducting voter registration drives with the threat of criminal investigation and penalties, resulting in a serious curtailment of nonpartisan efforts to engage voters. Florida also offers another example of how law enforcement can be used to intimidate voters directly. You heard Andrew talk about the experience of his client, Mr. Rivers, who was prosecuted by a local state attorney. Another set of prosecutions in Florida of people with felony convictions involved the Office of Statewide Prosecution. And this is an office that was created in the 80s to combat complex criminal cases like organized crime. And in 2022, just 5 days before Florida's primary election, Governor DeSantis announced the arrest of 20 people with felony convictions at a press conference. And flanked by over a dozen or so law enforcement officers, DeSantis claimed that all of these individuals knowingly voted while ineligible. But public records suggest that most, if not all, genuinely believed that they were eligible to vote, like Mr. Rivers. And the public announcement of those arrests had a chilling effect, scaring away eligible voters from voting, not just in Florida, but in other states. And we're now seeing similar efforts emerging at the federal level. The DOJ recently sued Orange County, California, And in that lawsuit, the DOJ is demanding the personal information about 17 non-citizens who were removed from the voter rolls. And 16 of these individuals apparently self-reported and asked to be removed. And in the rare instances when non-citizens have registered or voted, it's often the result of clerical error or confusion about eligibility. But if the DOJ begins prosecuting people for honest mistakes, the chilling effects could be enormous. Eligible Americans might decide it's safer not to vote at all. And whether or not these threats are fully carried out by the administration, the groundwork is being laid. The DOJ's new mission statement for the voting section, for example, barely mentions the Voting Rights Act. Instead, it emphasizes preventing voter fraud, which is exceedingly rare. It also mentions helping states identify non-citizens on their voter rolls, even though non-citizen voting is also exceedingly rare. Over the summer, the Civil Rights Division also began sending sweeping requests to states for information about their election systems and demanding states' voter rolls, including confidential voter information like their driver's licenses numbers and their social security numbers. At the same time, lawyers in the criminal division began reaching out to state officials, proposing an information sharing agreement related to instances of voting or election fraud. And soon after this outreach from the DOJ, the New York Times reported that the DOJ was actively exploring ways to bring criminal charges against election officials over how they manage their election systems. And earlier this week, the Washington Post reported that President Trump has escalated his demands for investigations and prosecutions related to the 2020 election. There are newly formed federal task forces like the DOJ's so-called Weaponization Working Group. The New Jersey United States Attorney's Office has an election integrity task force, and the Washington, D.C. U.S. Attorney's Office has an election accountability special unit. These new federal task force appear to provide a new infrastructure for shifting the DOJ's focus from protecting voters to intimidating those who administer elections. And the Weaponization Working Group was explicitly created to pursue officials who prosecuted Trump or others involved in the January 6th riots. And the U.S. Attorney task forces were started and are being led by members of the administration who have made false claims about previous elections and election fraud, pursued baseless litigation aimed at the president's political rivals, and threatened to use the DOJ to publicly name and shame individuals whom they don't have a basis for formally charging. And so all of this can mean that new investigations and prosecutions will be announced in the coming months, and not because of actual misconduct, but to cast doubt on the integrity of the people who make our elections work. To date, the individuals who have been directed to pursue these prosecutions have reportedly struggled to find any legal basis for them. But as I mentioned earlier, and as demonstrated by the experience in Florida, even the announcement of criminal investigations can have an impact on elections. Election officials who already face significant harassment and threats since 2020 may continue leaving their posts. The threat of criminal prosecution could also be used to pressure election officials to comply with unreasonable or unlawful requests. And the threat of criminal investigation may also prompt civil society organizations to retreat from their work to engage voters. And that, unfortunately, is the point. Thank you so much. I look forward to your questions.
Thanks much, Patrick. Needless to say, the potential chilling effect of those kinds of actions by the administration are definitely a real problem with the upcoming midterms. Well, we'd like to open the floor to Jake.
Thank you very much. Good afternoon and possibly still good morning. Jake Sussman here from in Durham, North Carolina, where I'm with Southern Coalition for Social Justice. We are an organization that's been around almost 20 years, and we primarily focus on voting rights, criminal legal justice, and environmental justice, and I run our criminal team. Before this, I had a criminal practice and had defended some folks charged with unlawful voting in North Carolina. I did prepare a PowerPoint, which I will sort of walk through. This is a case that our organization, along with Simpson Thacher, litigated, and we recently had success. We had success at the district court level, and then the Fourth Circuit affirmed. And, it's a little sui generis because it's about a North Carolina law that criminalizes ineligible voters, right? So every state where somebody's been disenfranchised, if they vote or attempt to vote, sort of what happens. In North Carolina, in this case, let me make sure I can do this. We had a statute that imposed strict liability. And at the time we filed in 2020, we understood it was the only statute imposing strict liability, Class I felony in North Carolina, if you voted without having been restored to the right of citizenship, regardless of whether you knew it or not. And as we've already heard, right, these laws are confusing. People get misinformation all the time. But in North Carolina, we had this particular kind of statute. For purposes of challenging this statute, as I'll explain later, we had to do a deep dive into the history of it. And unsurprisingly, in a place like North Carolina and a lot of places across the country, these laws were created in a context. So this was created in that post-Reconstruction era of the late 19th century, when the North Carolina General Assembly was being sort of retaken by conservative whites in power and passing all manner of laws to criminalize and disenfranchise Black citizens in North Carolina. And that's where this particular law, so we had the criminalization of being Black in North Carolina, which resulted in an extraordinary number of felonies. And then you had a strict liability law that said, if anybody with a felony tries to vote, we are going to give them another felony. Fast forwarding into more recent times, right, in 2013, Shelby County versus Holder, which folks here are probably familiar with, right, which eviscerated Section 5 of the Voting Rights Act. So as a result of that, a number of states, particularly in the South, started pushing out very ambitious legislation, including North Carolina. We had a number of cases swirling around here in North Carolina where our GOP legislature were operating, as the Fourth Circuit said, with almost surgical precision to target Black voters. And in 2017, it was very clear sort of who was being targeted under this strict liability law. That had resulted in a number of cases, at least big cases in North Carolina, where swaths of people were being picked up. This is sort of post-2016 election, where there was real focus on so-called voter election protection and integrity. One of these cases, the Charlotte mayor, who I actually represented, who had done his Rule 11, but then hadn't come back for sentencing. He had voted, sort of a good example where somebody, even a very high-profile person in Charlotte, went in to vote, didn't understand his rights, and was charged under this law. This was filed, this predates my joining SCSJ, so I just was a participant later on, but this was filed a very long time ago, 2020. The plaintiffs, our clients in this case, were two organizations that, like Patrick was mentioning, groups that get out the vote, groups that educate voters. And the argument here was that this strict liability law both had equal protection problems and due process problems, namely because, as we know as criminal defense lawyers, when you have a strict liability law, those are very hard to challenge. And then here we had real questions about how it was being enforced across the state. And what we sued the State Board of Elections, which is in charge of obviously maintaining the rolls, and then the individual elected district attorneys across the state who were enforcing this criminal statute. under the equal protection, right? We had here a law that was facially race neutral, but we were seeing disparate impact by the information that we were pulling together. One of the things we had to show was that it had been enacted with discriminatory intent. And as I had said at the sort of top, we had a pretty good legislative history about how and when, in what context this law was created. We engaged an expert, Jim Laludis, who is at UNC Chapel Hill, asked him to ascertain whether there was a historical relationship between race discrimination and the law. And his finding was that the voter prosecution was an obvious instrument of choice in legislative efforts to obstruct Black political participation in post-war Reconstruction era. A really excellent expert report, and sort of to the extent that we're able to, again, bring in the historical context of how and why these laws are passed in the first place, was very powerful. And as I mentioned, there had been a lot of litigation in North Carolina where we have been sort of ground zero for a number of different things, not always great in the voter context. We had sort of been able to kind of create a record that there were these continuing efforts to target Black voters in North Carolina. And then some of the data that we were able to establish during the discovery clearly showed that there was an over-representation in Black folks who were being targeted by investigations and prosecutions. This is one of those things where, as a lawyer, every once in a while you get like a court order or something where you just want to put it up on your wall. This is one of those. This is a case where the state of North Carolina did not contest the historical background of how this law was created. They did not contest that, they didn't say it was defensible. And, in civil litigation, as some or many of you guys know, you can ask for admissions and you can send interrogatories to get the other side to sort of, show some of their cards. And in this case, we were able to secure what I think were pretty remarkable, and later, more importantly, what the court thought were pretty remarkable concessions, that the origin story of this statute was indefensible. What they claimed, their way of getting out of this, was that while the late 19th century creation of this law might have been infected by racism, that subsequent changes to the state constitution and other tweaks to the statutory framework indirectly cleansed the law. And that was their argument. And that's an argument sometimes that is made where you do have a law that's created in a particular context, but that subsequent changes have cleaned it up. Here, the court rejected that. And we were able to sort of show a through line that the statute in question here had remained essentially unchanged since the 19th century. So that's part of our equal protection claim, right? That you have this facially neutral law, but it was being applied in a discriminatory manner, and it was created with discriminatory intent. The other claim was due process, right? We have a strict liability statute, but in the course of discovery, what was really interesting was getting into the files of the State Board of Elections investigator, as well as not all, but most of the 42 elected DAs across North Carolina who got these cases referred out. The way the process would work is that the State Board of Election would do an investigation, and then they would refer it for prosecution. And you just had DAs taking very different approaches. Some DAs said, I don't see any mens rea here. I don't see any knowledge or intent. I'm not going to prosecute, even though the statute was strict liability. And then you had other DAs who would go forward with the fact that the person tried to vote regardless of what they had been told. And again, as we know, the challenge of facing those kinds of strict liability laws is significant. Here, in the context of a constitutionally protected right, the right to vote, there's a little bit heightened protection when the courts do their analysis. So in June of 2023, we file a motion for summary judgment in the Middle District of North Carolina under both the equal protection and due process. 2 days after we file our motion for summary judgment, and we later get this email through a public records request, Joshua Yost works out of Phil Berger's office. He is the highest ranking in the Senate, the North Carolina Senate, and Paul Cox was general counsel for the Board of Elections. And in the summer of 2023, kind of like on any given day, the General Assembly, the GOP-led General Assembly of North Carolina, was scheming of ways to further restrict access to the ballot. And they were putting together what became known as Senate Bill 747. And here, what you had was Senator Berger's office trying to figure out, was there a way for them to sort of derail our lawsuit by adding an intent requirement to this new package of laws? 747 gets passed in the summer of 2023 while our motion for summary judgment is pending. It is a terrible bill. The governor vetoes it, but he is then overridden. The only redeeming thing in this bill is that the GOP added an intent requirement to North Carolina voting. Just to show you just how bad that bill is, my colleagues in my office just finished a week-long trial in front of a different judge in the Middle District challenging other aspects of Senate Bill 747. But like I said, the one thing, and I've highlighted the additional language, is that this new statute, they amend the statute and they add a knowing requirement to voting if you are ineligible. So the question then in the course of this litigation, we had this great evidence, we believe, that this law violated equal protection and due process, and then the legislature appeared to be trying to clean it up. The question was whether that mooted our argument. Right? Was our case over because they had changed the law? And here, what they didn't do, they being the legislature, for unknown reasons, is they didn't make this law retroactive. They didn't repeal the earlier law. They just said, effective on October 1, 2023, you now have an intent requirement. So the question was, well, what about the hundreds potentially of people, and we found at least 200 cases during discovery that were still being reviewed for alleged unlawful voting pre-amendment. And in North Carolina, there's no statute of limitations on a felony. And so DAs were still potentially able to prosecute folks under the old law. It was sort of unusual. We don't often see this. Oftentimes when we see a change, you'll see that the old law was repealed or there's some clear retroactivity issue. And here again, our plaintiffs were about voter participation. And I think this came up in some of the earlier comments, which is that our argument was, if there is a prosecution for somebody under the old law, that is just going to create so much confusion going forward that it continues to impair the work of our clients. And so we were able to make this chilling effect argument that was mentioned before, saying the chilling effect of these prosecutions would be significant. And that for our clients in this particular context, it would be this unwarranted drain on resources to further educate voters. We prevailed with that argument. The court rejected our mootness argument, and the district court found both that there was equal protection violation here and a due process violation. The state appealed, despite the fact that it conceded the origin story of the statute. We happened to get a particularly terrific panel in the Fourth Circuit. The very first question that Judge Wynn, who is from North Carolina and was held off the Fourth Circuit because Jesse Helms would not let a Black man be on the Fourth Circuit for a very long time. His first question to the state AG was, why are you here? I've never, I feel like I've always been on the receiving end of those kinds of conversations or questions, and this was really quite nice to see. The court was sort of befuddled. Why was the state pushing this? Did the state really want the Fourth Circuit to rule on what the findings of the district court when in fact the state had admitted that there was discriminatory intent and admitted that there was disparate impact on Black voters? And wondered why hadn't the General Assembly repealed the statute? So the Fourth Circuit wrote a very tight and good affirming opinion. It only found on the equal protection. It did not need to find on the due process. As a criminal defense lawyer, I was very interested to see if the court would rule on the due process, because it did deal with this sort of strict liability and ways we might be able to challenge some of those laws. But we now have a good Fourth Circuit opinion on equal protection violation for this particular law, and we're now trying to get some fees from the state. And so what that means is that going forward, again, this is like a small victory, right, in this larger context of criminalizing voting. This is for cases where people have already been disenfranchised, but there's confusion about whether they can vote again. And here we finally have moved away from a law that really catches a person a second time very unfairly. And so now people going forward, the state will have to find intent. Thank you for indulging me, and I'm going to take down my screen.
Jake, thank you so much. Patrick, Andrew, very, very informative. And it's funny, as I want to get to the questions in the chat, but as I hear all three of you speak on these issues, it's funny how it all intertwines from my perspective. Seth, I think you'll agree with this. I actually took on a case as well. I got cross-designated as a public defender in Miami, and I started litigating the issues. And some of the arguments that I tried to argue regarding due process, Jake, they were denied in that context. But hearing you speak on that issue, I tried to weave that in. Andrew, as I hear you speak on the jury instructions, well, through the work of the committee now, we have standard jury instructions on these cases. And that was due in part based on the feedback we were hearing from Andrew and others who tried cases. And we were seeing different jury instructions depending on where the case was tried in the state. So to create some uniformity, the committee worked with Brennan, Southern Poverty Law Center, League of Women Voters, and we provided that. Again, getting involved, trying to do something about this issue to help our clients. The manner of litigating these cases and the investigations, Patrick, as I heard you speak, I've had multiple consults from organizations who are being investigated, being harassed. And as I see Lisa Wayne's question regarding obstruction of justice, the obstruction of justice issues becomes a huge problem for entities defending themselves, because they start getting subpoenas. Sometimes they don't. Sometimes they just walk in unannounced, start asking questions. And depending on how questions are answered to Lisa's question, you could be deemed to have obstruction of justice. So I want to kind of let you know how impressed I was with everything everybody said. And it resonates with me in a variety of different ways from my individual experiences working on this committee. So it's very relevant and temporal. But as we look at obstruction of justice as a charge, and the way Lisa asked the question is, you're seeing it a lot in the defending of immigrants. I see the obstruction of justice issue in these cases as the manner in which you respond as an entity, these organizations. I had a canvasser approach me about being investigated, what to do. Lists are being asked of these entities, right? And these are all volunteer positions. These poor people think they're doing the work of the people, and now they're scared to go out and do it again because people are asking about them. So I throw it out there for the panel to discuss the obstruction of justice issue, and if you have an opinion on it. I see it from the subpoena request, but I'm wondering if anybody else is seeing it from any other angle.
I've I haven't seen it from essentially us as the attorneys having any issues, but I mean we've had cases here in Orlando where you have somebody that gets arrested on what we would challenge and very likely win as a bad stop, and they end up getting a no valid license or something like this. Anything to get them into law enforcement custody, and as soon as they hit the jail, ice hole. And I mean, I've had multiple cases now that the actual criminal charges, instead of fighting them, the state knows they're bogus, immediately drops them, and the person never gets out of detention because they just get moved to ICE custody. And I think there are going to be situations where, I mean, I'm sure there have been already, of people who are US citizens who are being confused. There are errors in the system. They don't have the right documents with them at the time. And I mean, I think it's very likely, if it hasn't happened already, that US citizens are going to be deported to who knows where because they can't show their paperwork, essentially. And I mean, we've seen it already. And for me, that's not just a due process issue, but also individual states and the individual counties, I think, have a claim that their ability to prosecute cases is being basically superseded by the federal government's choices of how to enforce immigration.
Well, you're seeing that in domestic cases. I mean, no doubt. I have prosecutors complaining to me that they can't bring on cases because their victims won't come because they're afraid of retribution. So I'm with you. Jake, Patrick, do you have any comments on the obstruction of justice issue that you'd like to share with us?
I mean, only that we're seeing that, at least at the level of the fear and concern, right? So some of the plaintiffs in this lawsuit that I just talked about, right? Groups that are on the ground trying to give advice to people, are reading the news and hearing from different people that you need to be ready to receive a subpoena. You need to be ready for that knock on the door to make sure that so to the extent that we are, and, both trying to give advice to some of these organizations, it's sort of the same with, groups that are helping folks get out of states, go to states so they can have, surgeries or abortions, right? So many things are being criminalized now, right? Assisting people who are trying to get, flex their constitutional rights or their fundamental rights to do certain things. So we're seeing it in the voting context. None of our, knock on wood, none of our folks that we've been advising are right now sort of in a production phase of having, with a grand jury subpoena. But it's been something that we're trying to be ahead of the curve on and trying to give it as much information out as possible.
Well, I know Campaign Legal Center, another organization that the committee's been working on, reached out to me recently. And there's all these laws. And Patrick, you alluded to this. So I'd love to get your comments on it. And these are nonsensical. I really don't want to get into my soapbox that Seth is too tired and the committee members are too tired on. I usually go on a rant for a little bit to just kind of to cleanse my soul of the disgust, that I'm feeling. But there's these laws that have criminalized in Florida, made it a third-degree felony without a mens rea requirement, Jake, to collect petitions. So unless you are registered, so I mean, now you have a volunteer person, usually elderly, let's say they believe in the environment and they go to work collecting signatures for an environmental initiative, which, a certain party doesn't really care about. So right away, the way that they're collecting their signatures, all these unnecessary processes are, and there's lawsuits. Legal Women Voters are involved in litigation in Florida. Campaign Legal Center, I know, is going after it. And they've criminalized the act of just holding signatures. That's it. So obviously there's a lot of case law in Florida. Andrew, I'm sure you're aware everywhere, but in Florida I've dealt with it from a fraud construct. You need that mens rea requirement. There has to be a willfulness to commit some sort of act that's criminal, just holding signatures. But Patrick, are you seeing that in states throughout? These useless, obviously hindrance, impediment, obstacle-oriented laws criminalizing, as Lisa put it, over-criminalizing what would seem to be a ministerial function in the voting process.
Yeah, so unfortunately we're seeing those types of laws with regards to voter registration, also with regards to collecting signatures to put things on the ballot. And these laws will impose massive civil fines and or criminal penalties. And you're seeing them in states like Florida where people have been able to get things on the ballot like Amendment 4 and get them passed. And so they're being, enacted in these states in response to, things that voters are doing that the legislature doesn't like.
Yeah. Uh, I mean, we've heard about the water, giving somebody water in Georgia, and that's the example that's thrown out there. But I've received calls as a committee member and on an individual basis on other ridiculous that when I'm hearing it, I have to actually look up the statute because I can't believe somebody went to the trouble of criminalizing this. So, I'll speak on my behalf, not on behalf of any CDL. It's pretty clear to me what the plan here is. I think it's pretty obvious, right? Nothing about clearing up eligibility, as Andrew alluded to in Florida. They got rid of the database, which was helping in that regard. It is all about muddling and confusing the issue to discourage participation. So, uh, you know, I, Seth, are there any questions that you're seeing or that you want to ask? I don't want to monopolize the entire Q&A. You're muted, Seth.
Thanks. I don't know if any of our panelists are able to speak to this, but there is one question about what federal legislation is being done to open up the restoration of voting rights to all citizens. I don't know if any of you.
So I'm happy to take that on. So there's at least two bills that have been introduced. There's one bill known as the Democracy Restoration Act, which would restore the right to vote in federal elections to everyone who's not currently imprisoned for a felony conviction. The other bill, I'm forgetting the name, was introduced by one of the representatives from Massachusetts, and I believe the senator from Maine, but it would eliminate felony disenfranchisement in federal elections. And so it would allow people in prison to vote in federal elections.
Wonderful. Great.
Seth, if I can for a minute, just kind of on that thought process. One of the things that I think has been an advantage for me is having previously worked in politics. I have a really good relationship with all of my state reps and state senators here locally in Central Florida, all the way down to the city commission. I mean, I know a lot of these elected officials. I mean, we're on first name basis, which is not something everybody has time to do to be in that world and understand it. But what I can tell you is specifically in the voter context, in Florida, we have broad sunshine laws for public records. So one of the things that I was able to do is request all of the communication between there was a whistleblower in the Alachua cases, which was just this regular civilian guy who was doing research on people who cast ballots and then going to look at the clerk of court to see if they had any convictions. And I don't know what kind of individual. I met him in person twice. I didn't really have a conversation with him. He was just there for the trial. But he spent a considerable amount of time just doing his own research in his home to see who had potentially voted who was not eligible, and doing a public records request for every time his email hit the Alachua County State Attorney's Office, or every time his email hit FDLE investigators, which is the Florida Department of Law Enforcement. There were a lot of context that I was able to get about how these prosecutions even started, and trying to find that person's connection to the current governor wasn't that difficult to figure out that that person was in the circle kind of trying to stir up more issues. But if you're in a state and you have broad public records accessibility, yeah, sometimes they try to make it expensive, but reach out to your local organizations that do this kind of work and see, because larger organizations are going to have a bigger budget than, I mean, my law firm's grown quite a bit in the last 3 years, but I mean, I don't know that I would be comfortable, paying $5, $10, $20,000 for a certain public records request. But if you have something that's a few $100, I mean, that's where those sort of relationships come in, because I know I've helped solo attorneys with explaining public records requests, and hey, if this is how much they're charging, pay this much, be very specific on your request, get a smaller request to see if it's something that looks like it's going to pan out, and then you can ask for more later. And in the voting context, like I know Jake mentioned in his presentation that he didn't get that email from the senator to tell public records request later. And those are kind of the ways that if you can do this pre-trial, you're going into trial with a lot more information that the prosecutor may not even have.
Well, let me ask you about that, because that, you and I have talked about it. I know you and I were talking when you were trying the case. You were reaching out to me and we were having conversations. And one of the things that we've talked about a lot in the committee is motion practice with these. And there's reasons to and not to, depending on the facts of the case. Your case is very unique. One of our committee members represented the election supervisor for Alachua, Caleb Canyon. So we're familiar with the facts of that case. But a public records request, a lot of times you're dissuaded from it because you will ask for something and the bill you get is like 10, 15, 20,000 bucks. And then it discourages. So what about filing motions to compel with the state, or through, in Florida, we have depositions. That don't be haters, everybody on the chat. In state cases, we can take depos. I took depositions in my case. What about that? What about those tools? Like maybe going through the state and getting the court involved in understanding just how crappy these cases are. What do you
Yeah, so I don't believe I did one in Mr. Rivers' case specifically, but I've done motions to compel. The rules in Florida basically are 15 days after I file a demand for discovery, I'm supposed to have it. I can count on one hand the number of times I've actually had discovery in 15 days, and they were only on misdemeanor cases. So misdemeanor cases that I took over from somebody else, and when I was in court that day, the judge directed the state to provide it to me like that day. So the things that you can do, you can do a motion to compel. I've done it previously, and generally a lot of times judges are going to say that's state communication with a witness, so it's protected. And then my answer has been, it's not protected. That's a prior statement that if it's inconsistent, I need it. So there's ways to keep asking. It's going to depend on your judge. Mr. Rivers' case, we had a long conversation about, do we file a motion to dismiss, based on essentially due process, selective prosecution, all kinds of different, bases. And I let Mr. Rivers be a pretty big part of his defense, which, I know some defense attorneys, they're like, strategy is mine. Here are the 3 decisions you have: who to hire, whether to plea or go to trial, and whether to testify at trial. Those are client decisions. Everything else are mine, right? I tend to want my clients to be more involved in some of the strategic parts of it, especially in a case like this, where we're not disputing whether the actions took place. We're disputing the intent. We're disputing whether he had the mens rea or even the capacity to understand what the law was or wasn't, and the changes that took place around the time of him voting. So I think being intentional about including your client, because the other thing too is I also will fight cases a little bit more publicly than most people are comfortable doing. I have good relationships with people in the media. These voter fraud cases, though, they get outside of the state. They become national spotlight cases. And you have to be very smart and very intentional about how you are presenting your case whenever you do make a comment.
Well,
I-
let me ask you about that the point you just made right now, because what you just described in Florida is what we call a C4 motion to dismiss, and it's
Mhm.
the equivalent of a summary judgment motion in a criminal arena, right?
Mhm.
When the facts are not in dispute, right? And the rule procedures changed in Florida now so that your client no longer has to attest to the facts. So we don't have to worry about being impeached on the motion itself, right?
Mhm.
Um, what are your thoughts about, and now Jake, you've practiced criminal as well, about filing these type of motions? Because, to me, when you have these constructs, not enough people are treating these as fraud cases. And that's what it's voter fraud,
Mhm.
fraud in the application. So defense concepts of fraud defense, I think, are very relevant and useful in your toolbox here. And I don't see it utilized enough. So if you have, and I'll open it up for panel discussion, because when I see Jake's dissertation on legislative history, I did that in my, you want to explain the injustice that's happening in this arena. And that is going to soften up the judge, in my opinion, to be more sympathetic about just how ridiculous this case is to allege that fraud took place. There's case law in Florida regarding that intent can be a C4 issue. You can't usually when you say intent, oh, it's a question of fact, leave it to the jury. But in fraud cases, there is a carve out for facts not in evidence regarding intent. So, do you have any suggestions or any commentary? And I'll throw that out to everybody on that issue, because I see that being an issue in most of these cases that I've analyzed.
Yeah, I think and obviously I spoke about the Rivers case because one of the reasons we stayed away from some of the motion practice was because at the time we were going into trial, he was aware, because I made him aware of the reason why I actually think they found him not guilty on count one, but guilty on count two. And that was the plea that took place in between. So what our concern was, and in my conversations with the state, I never picked up on the fact that the state was super aware of that fact specifically. Like the timeline was different. He's charged 2 years later. Like there was a bunch of stuff, and I didn't really ever pick up that the state realized the plea that took place in the interim between the two acts. So what I did not want to do was bring light to it in this specific case. But I do think that there's going to be a place in a lot of these types of cases to bring arguments. And the other thing I didn't bring up is Mr. Rivers is a white guy. So and I mean, I actually never asked him, but I have a pretty good idea who he voted for. I never asked him because it doesn't matter to me, right? Like, I want you, if you're eligible to vote, you should vote. I don't particularly have to agree with you. Your rights are your rights. And it was one of those things to me that I want, if you are eligible to vote, I want you to be able to vote and I want you to vote. I want you to be educated on it, of course, but also it's a fundamental right in our country. And I do think that there's a lot of room for C4 motions, which, gosh, I think the rule literally just changed like this week of what they're going to be called, like G2 motions or something like that.
And they no longer need to be attested
Yep.
with your client swearing under oath.
Mhm.
The strategy there is if just make it a self-serving motion, and then you could take judicial notice of the court file, and then everybody sees what your client said without subjecting them to cross. So I like that angle of it. But now you don't even have to worry about any repercussions. So all the more reason for those that were concerned, the naysayers, to say don't file these motions because your client, it's a sworn statement.
I
You
just
know,
wanted to interject that Cynthia Orr mentioned that they have there's felony cases in Texas for canvassing work that she was noting, and I just want to make sure that anybody who is on this webinar should know that we want to know if there are any pending cases whatsoever of voting related prosecutions. Our committee really wants to be informed and help in any way we can. And there's a lot of institutional knowledge that our committee has by working on these issues for the last few years that we can pass on. So, but we definitely want to know about any voting related prosecutions.
the canvassing in Florida has been investigations. We've discussed that in the committee, Seth, but I haven't seen a prosecution. That's interesting to me of canvassing work. I've talked to canvassers. I've talked to the entities that they're working for. I know there's investigations, but I haven't seen one come all the way through and be a criminal prosecution. So I'd be fascinated to hear more about that.
Yeah. We have a little bit more time. Maybe a quick question for Patrick that we have here. Patrick, what legal or policy reforms do you think are most urgently needed to counter the trend of, the chilling effect from prosecutions on both election administrators and voters themselves?
Yeah, so thanks for that question. So these prosecutions are going to be federal. And so any meaningful legal or policy reforms are going to need to come from Congress. And that's just unlikely to happen before the midterms. That said, there are, protections that could help. So the First Amendment, for example, protects election officials and pro-voter groups from retaliation based on their speech and association. There's also federal and state law that prohibit federal officials from intimidating voters or those who help them. And although it's rare, voters can sue DOJ officials under anti-intimidation law in federal court. There's actually one case, Smith versus Meese, where it involved the DOJ going after black political actors in Alabama using a very discriminatory practice of criminal investigations and prosecutions around before the election. And the 11th Circuit issued a good ruling in that case. And if the DOJ does begin to bring these investigations and prosecutions, it's important that courts, act swiftly to dismiss any legally unsound prosecutions.
Great, thank you.
There's some questions, Seth, I'm looking at now. If you want to, Warren Wolf and some other gentlemen, did you see that?
I did. Do you want to go ahead?
Yeah. So I don't know if I understand the question. It says, how much time is reasonable to respond to a knock on the front door while you sleep?
I'm not sure I understand.
I don't know if I.
If you want to further clarify, Warren, if you're still
Yeah.
send us another question.
And I saw Frank Riccios talk about, he's in Connecticut. There's current criminal prosecutions of a handful of persons for voting fraud. Man, we would love to hear about that. Please, she's responding to you. And if you could be our conduit, I don't believe we have a committee member from Connecticut. We have from a bunch of states, but we would love to have you. If you're not a member of NACDL, join NACDL and join our committee. We need intel from as many states as possible. Seth is kind of our national guy and is dealing with organizations on a national level. Before we have everybody give a final comment, Seth, if you want to talk a little bit about the work you're doing uh, with the particular organization that I know you're working with, that I think people would love to hear about that.
Well, our committee and I've been attending coalition meetings with folks from the Brennan Center, from NAACP Legal Defense Fund, ACLU, and other representatives of organizations that are dedicated and committed to number one, expanding voting rights in general, but in particular with regard to returning citizens, people who've been previously convicted of a crime. And also providing information to all voters, and especially to returning citizens, and also people currently incarcerated who actually have the ability and legal ability and opportunity to vote, but might not know of it, don't know what the rules are. As Andrew mentioned, like in Florida, the rules can be extremely confusing, vague, unclear. So we have our committee and we've had interns in the past who worked on and participated in preparing voter guides for returning citizens and presently incarcerated individuals. And also through this work, we've worked in the area of expanding the voting rights of returning citizens and expanding the restoration of voting rights. So.
And Patrick, along the lines of what you were discussing, and in that general theme, one of the things the committee has worked on as well is we've created a kind of a know your rights sheet for canvassers, because what was happening is they were being approached by law enforcement to be intimidated. And so the long and the short of the work that we put together through the committee is letting them know they can assert their right to counsel in that context. And they were so appreciative. I spoke in front of NAACP on this. I had a ton of Q&A on it. They're nervous about being approached. What are you doing? Who are you getting signatures for? It is, and you're only seeing certain groups being targeted, right? I think we're clear who these organizations are. But have you seen that as well in your work, where people are being approached just simply for doing volunteer work?
So I'm not a criminal defense attorney, which may be apparent to everybody already, but I've heard anecdotes through the work that I've done in Florida in partnership with Seth and Ray and others of people who did canvassing and were approached. It's likely the same people that approached Ray, but we have heard anecdotes of that happening.
Okay. Well, I don't know if we have any other questions, but if not, Seth, do we want to just let each panel member give some parting thoughts on the subject matter they spoke to?
That would be perfect. Yes.
Awesome.
Why don't we start with Andrew? Go in order.
All right.
All right. So again, thank you all for attending. These events are incredibly important. I recently attended my first in-person NACDL event back in Tulsa at the Race Matters conference, where I saw Ray. Joining NACDL is huge. Understanding sort of the bigger picture of things that are going on nationwide is incredibly important for your practice area in the state that you're in. It allows you to take things from other states, ways that people are making arguments, and see how it applies to the cases that you're making arguments for. It's been really valuable to me, some of the relationships. And what it also does too is it gives you lawyers to send people to that take this stuff seriously. Because if you're going to an NACDL event, this is what you do. Right? You want to do something that's important, that has an impact. And the other criminal defense attorneys that are coming to these events are folks that want to do good work. And if we're being honest, sometimes we just want to go to Vegas or something like that. But thank you guys so much for your time. I appreciate it. If you guys need anything, obviously, reach out to NACDL. Darling Law is my law firm. Andrew at darlinglaw.com is my email. I can put it in the chat if that works. But I'm always willing to talk to folks. I appreciate it. Thank you so much. And this is something that's incredibly important. So thank you, NACDL and Seth and Ray and other panelists, Patrick and Jake, for being on here. Like, I appreciate it. And thank you guys so much.
Thank you, Andrew. We really appreciate your participation and wisdom you've gained through the work you've done in these cases. Patrick, you're next.
So thanks everyone for attending, and thank you so much for inviting me to participate. I wish, of course, that this committee of lawyers didn't exist, but I'm glad that it does. This is a very important issue. At the Brennan Center, we work on felony disenfranchisement at the state and federal level. And so if there's any way that I could potentially be helpful, acknowledging that I'm not a criminal defense lawyer, please let me know. In Florida, for example, we filed amicus briefs in a number of the cases. We also have a deep understanding of the confusion in Florida, just given the work that we did and civil litigation that we filed. And so to the extent that I could be helpful, I'm happy to do so.
And listen, I thank you so much, Patrick. You've been great. And I know you're being self-deprecating, saying you don't do criminal defense, but your experience to me is crucial. And one of the things that we've talked about in the committee extensively is expert work. And I mean, a past president who we hold in incredibly high esteem, Cynthia Orr, she had to leave the chat, but she's the one that was asking for your contact info for potential expert work. So while you may not be a criminal defense lawyer, the wealth of knowledge that you have on these issues, and what I would encourage all practitioners to think about is when we're going into the knowledge mens rea requirement, if you can create the issue of confusion at the time that the registration took place, that is direct evidence of what's in the ether. You're making it relevant, and you can make it a topic of discussion through potentially someone with Patrick's knowledge. And what we've been trying to do in the committee is get experts out there. So I don't want to volunteer you, Patrick, but somebody with your knowledge, at least consult with somebody that has that knowledge. Cecile Spoon, I mean, from League of Women Voters is another person that comes to mind. People that have an understanding of how screwed up this is to determine eligibility, and you can educate your judge. You can cite to them in motion practice. So, Patrick, I think you are a huge asset to anybody that really wants to litigate one of these cases, and I thank you so much for being here.
Thank you.
Yeah.
I'll put my email in the chat.
Great. Thank you. And then Jake.
Yeah, again, thank you all, Ray and Seth, for your leadership on this, and Lisa as well. It's such an important committee, so definitely an honor to be here along with Andrew and Patrick. I'll also put a plug in, for folks, particularly in southern states who are looking at this intersection of voting and criminalization and want to strategize, about how do we use public records requests and, in civil litigation, as I've learned that as I'm doing more, you just get a ton of discovery, right? We have a treasure trove of information now about decision-making processes in North Carolina. That's not going to do you any good in Florida. But to the extent we can think about ways of trying to get access to that information to then support a motion to show voter confusion, disparate impact, selective prosecution, I think that's where some of the game is, and we're here to help. So thanks again.
And Jake, I think and I told you this when you presented to the committee, I think you provide a great template for explaining the confusion in the motion practice, because I think that's ultimately where you won your case, right? I mean, you did such an excellent job, your team of explaining the confusion and the effects of this creation. So I looked at what you did there as something that we need to incorporate into the criminal motions as well. I think it's very relevant. So thank you.
And okay, I think we're going to turn it over back to the people who really run the show here and help us survive. Go ahead. Tamara.
Thank you, everyone. Thanks, Seth. Thanks, everyone, for attending this afternoon's conversation. And a huge thank you to our panelists, as well as our moderators, Seth and Ray. Just as a notice, this information will be recorded, or the recording will be shared via email, and the related materials will be shared as well, and they'll also be available online. And I will pass it over to Monica, who I think had one more announcement.
Thank you, Tamara, and thank you to our panelists and our moderators. This is always an excellent topic area, and I hope that those of you who joined us learned a lot.